the cloud beginning right now. So we're recording this, and I sometimes put this down later. If you're ever looking for resources, if you go to our website, we have a lawyer to lawyer section on our website, which contains this stuff. So let me share screen again. And when you share screen, it records what you're sharing. So it can be effective when you play them back about whether who's talking and whether you're showing an exhibit or not. For instance, and you can pin a video. If you go up to the three dots on the right-hand side of your screen, and it'll say pin, and you click pin, and then you pin my video, and then that's the person you're recording during that time. I can also unpin or unshare myself as I like as well. Let me go back and share my screen. And so then there's a thing that says remove pin in the top left corner, and I've removed my pin. Now that may not change that much on your screen, but it certainly is changing it on mine. I'm going to go back to sharing my screen. So it's easy to record. You click record, you record it to the cloud, and you pin the video on the deponent. And then Zoom has your recording, and then about 15 minutes after you're done recording, they send you an email with a link to that video. You take that video. I did this yesterday, and I sit and I forward that video, that link to the opposing counsel, and I've now just recorded the video and I produced it to the other side. You can also, and then if I'm going to go to trial later on, I can go to my cloud and I can get that video, and I can have someone sync it to the transcript or whatever else I want to do with it. So it's even easier than I used to record all these things. I have a little Sony Handycam. I go to different depositions. I record a lot of depositions because we use them later for trial. Zoom is easier to do it, I find. Sharing screen makes it easier to use exhibits. You can highlight PDFs while you're talking. You show deponents documents on the screen that they cannot escape from. I have found that it seems to work better. I get more admissions from people. You all are sitting there looking at your screen right now, and if I show you a document and highlight it and say, isn't that true? It's hard to wiggle away from versus handing them a document across the table in a conference room, have their lawyer look at it, just, kind of say, point to something else on the document, that kind of stuff. It makes me get organized quicker than I would otherwise. I hate to say that, but it's true. I'm not grabbing my exhibits while I'm talking to the person. I have to get them together, organize them, and save them. I get to move around from exhibits. I'm going to show you this in a minute. I have, people say, hey, how do you know that the other side's not cheating? How do you know that they're not looking at their notes or they're not whispering to each other? Well, I haven't found that to be the case. I've done a lot of these Zoom depositions. I've had some pauses. I've had some other stuff. I caught a lawyer texting his client saying, take a break, take a break, take a break. And then they took a break, and then they got back on the thing. And I said, was your lawyer just texting you, telling you to take a break? Yes. Okay, fine. No worries. So that can happen for sure. But it's just as hard to cheat and do that as it would be, I think, anywhere else. Now, the problem is that the opponent could have something on their screen with notes to themselves. Well, it is what it is, right? So the clients and co-counsel can easily attend. I do depositions with co-counsel in different states or different cities, my clients in their home somewhere. It's easier for people to attend and watch, but it is, as I said before, it is not better for PowerPoint. But look, I can highlight this and I can yellow this and I can say, don't you agree, Mr. Simpkins? Don't you agree, Mr. Bernstein? I'm just looking at some of the faces I see on here, that this is not better for PowerPoint. Yeah, okay, fine. So I do that all the time too. So here's the basics, quick. You get an account, you pay for an account, you practice a little bit, you pin videos, you unpin a video. I have a background. So what I did, I have this camera that I'm pointing at in my office. I went in and I took a picture from this camera, and on my laptop that I have that be my background. I know some other mediators and I know some other people to do it. So then I can look like in my office all the time. So in the bottom thing where in the bottom left-hand corner, you can set a background. You can choose a picture of your laptop. You can choose a background. I have other fun stuff like the office waiting room or like the throne from Game of Thrones, the Iron Throne or something. You can have fun with that too. So how do you do it? You notice a Depo by Zoom. You set up the Zoom meeting in your own account and you send your link. Then when you do the Depo, you click and record and go. If you forget to record, like I did when I began this CLE, you stop, you go, you start recording, and you're fine. The likelihood that you're going to use the beginning of a deposition at trial is unlikely too. So I like to do it myself. It's not just for a sake of control. I find if it's my Zoom account on my link, I can send it to my clients easier. I can do it easier. Literally this morning, I got a text message from a co-counsel saying, we got a hearing at 10:30. Where's that link? And we had to go find emails and find that. So now it is okay. Alaris or other court reporters, my court reporter, they can set it up themselves. They can give you the Zoom link too. That can work too. And I do that sometimes as well. So have your exhibits ready to go. Have your exhibits ready to go and open in your computer. Have them ready to go and open, because there's nothing like looking for exhibits when you don't know where they are. So if you want to do that, you have them open in your PDF viewer, and I have them right here, and you have them ready to go. Hey, Steve, how you doing? Hold on, Steve. Hey, I'm asking, I have muted everybody for sake, and Steve, I can unmute you, but if you have a question can everybody use the chat feature to have a question? So if this is another thing, thanks, Steve. If you can put your questions in a chat, and then I'll be able to truck along, and then I will do it later. So you can have your exhibits. Here's a file folder this is on my X drive. I have labeled all of my exhibits ready to go for a deposition, and I name them with the exhibit name. I don't say this is this bait stamp, this is that bait stamp. I have them here ready to go. I can open them from there, and I can also but I also have my my PDF, my Adobe open. And then what I can do is and I just opened it now while I'm talking to you. Again, I already had it up, but I'm going to share screen, and I have this, and I am sharing this with you. So then I have, this is what I use during the deposition. This is my Adobe is open. It's ready to go. I'm going to get rid of this so you can see it bigger. I have different exhibits at the top, as you can see, if you can see with my cursor, and I can switch from exhibit 22. This is my designee notice that I want to, this is their interrogatories. And then I can have different exhibits that I can use, and I have them ready to go, and they're marked, and I type in, you can see down here, I type in right here what exhibit it is. There you go. So have your exhibits ready to go, so you're not fumbling around and looking for them. And if you do fumble a little bit, that's okay. That's not that big of a deal to fumble around a little bit and to get it. So prep witnesses by Zoom at least the day before. Don't prep them by phone. Don't prep them by any other way other than Zoom. The reason why is that you want to make sure that they know Zoom and they get it. You don't want the first time they're ever using Zoom to be the day when they do their depo. You do it before. I have that as a requirement for everybody. And people say, oh, can't we just do it on the phone? Nope, you can't. You got to do it by Zoom so that they get it. So that if they have earphones that don't work, I can't tell you how many times I've had this happen. The earphones don't work. They try to do it on their iPad, but it won't work. They got to do it on their computer. They have a dog or kids in the background. Their camera shows them like this the whole time, and you see the side of their face. I know you guys who've done a lot of Zoom. I see some of you on here. I know some mediators and some other stuff. You guys get that all the time, this crazy stuff. Here's what a notice looks like. It's a notice of video by Zoom conference deposition. This is one of the forms I pulled out. And you say, isn't it true, sir? Isn't it true that the videographer for this deposition is going to be a member of Burger Law? Isn't that true? Yes, it is. Okay. That's one thing you do. That's what I do. I highlight documents to people. I show them to them. I ask them if things are true or not true. I think it's more effective than when you're sitting across the table from them in a traditional deposition. So how is Zoom different? How is Zoom Depositions different? Here's how they're different. Well, you can share the screen with exhibits. You can use and blow up language very effectively. Have them ready to show and go. Don't open them. Try to find them where they're saved for the first time during the deposition. Change the file names of the documents to 1, 2, 3, 4, 5 and a description. You're not going to have them saved for that, but you're going to do that. You're going to do that for this. Have them saved. Share a Google file with the opponents the day before the deposition so they get all the documents. Let's say you have a document where you have a pile of stuff produced and the other side doesn't know what you're going to use and what not use. Frequently, I give them all to the other side the day before. So they have them all. So there's no delay in a Zoom deposition. No one is sitting there going, well, wait a minute. You didn't give me this exhibit. You didn't give me that exhibit. Oh yeah, I did. Here's what I did. And I'm going to show you this shared file. And you have this, here you go. Here it is right here. So here I'm sharing this. And now I have, this is my, I don't want to show you that. That's another thing. So you have a shared file with your, I do it on Google where I share my, I have this shared file. This is my email inbox. You can see what I got, but here's what I have. I have a drive. I have a shared documents. I share these documents with all the opposing counsel, all my co-counsel. Everybody has these documents, these exhibits. I mark them. I change the name of them to exhibit whatever, and I add to them as I go. I'm going to show you that in a minute as well. So that can be very effective. Then I'm pulling exhibits off the same shared file. You can do that in Dropbox. You can do it in Google Drive, wherever you keep your stuff, you can do that. I find that to be very effective. So, and you can also see, you can flip between sharing screens. I can share something with you. I can go, I can share different stuff, and it can be very effective. You can make exhibits during the deposition. So here's an example of that. So here's what I did. I have this exhibit. I have exhibit 4, pre-shift activity. I'm going to open it. I open that document. And as I'm going through in this document, this document has morphed over about 5 depots. I had it typed up what I thought some pre-shift activity might be in Wisconsin, and the witness told me I wasn't wrong. So I can't edit this one because this one's a real exhibit. This is literally a real exhibit and hopefully a big case, we'll see. And then I delete stuff. I delete stuff that he doesn't agree with me. I literally typed in this material while he is telling me stuff. I am typing stuff in, and then I say, do you agree with all of this? Yes, I do. I mark it as exhibit. Now look here, this is interesting. I have a couple versions of this document. This is 4A, because the first opponent I did it, they said, okay, yes, this is correct. Okay, I'm saving this as 4. It's shared with everybody else. Everybody else knows it. Then I had another designee a few days later, and she added some stuff. And so I said, okay, fine, you're going to add some stuff. I'm going to call this 4A. And then now this is officially 4A. So you can make exhibits as you go. It used to be that you'd have a thing, you'd have a checkbox. Do you agree with this? Yes and no. It was a good, effective technique I know a lot of people use. Now you can just do that right on the screen. The other thing you can do is, let me see, I want to keep on my PowerPoint. By the way, everybody, you should have all gotten an email this morning with a link to a Google Drive folder with all the materials from today. So you can look for and mark new exhibits during the deposition. And I did this literally like yesterday. So let's say you have a deponent that's not going with you or says something. What if you're doing a car crash case and you want to get the rules of the road? Google rules of the road, bring it up and show them. So here's some things I've done recently. So I had a deponent who, let me show you these. So this is all in still that same one. So I have, I'm going to move this a little bit. So I have this deponent who, so I'm doing a deposition yesterday, and they're describing me, I don't want to get into the details of the case, but they're describing me events in a med mal case where someone passed away. And so I Google, what are diabetic seizure symptoms? And then I start asking questions, and I Google it and I have it. And I literally started asking these questions. Okay. And then here I had another one that was really, I thought was very interesting. Was I'm going to go to this right here, and I have them up on another screen. But I was taking a depo, and this deponent was denying that these corrections officers had events where they would get attacked and stuff pre and post shift activity, which is one of these cases I have. So I literally Google it and I find these articles, and during the deposition, I pull this article up, I share screen with them, I show them, and I show them this article, and I hope you guys can see it, where this newspaper, this TV station, it's now Exhibit 46 in the depo. This TV station did a Freedom of Information Act request and found an insane amount of assaults on corrections officers. And I just bolded it, and I showed them, and I said, you're the head of security for the whole Wisconsin DOC during this time. Did you know about this? Yes. And I started asking him questions, and the gems out of this article that I found are amazing about how dangerous this is. And he agreed with me about everything on this as soon as he saw it, and he admitted a lot of stuff. So that can be very effective. So you don't have that ability in a traditional in the conference room deposition. So I find that to be effective. If they're giving you their long non-answer in a question, rather than just sitting there and listening to it, open it. I have two screens. I have my main screen. I have another screen over here. I open stuff on my other screen. It's where my notes are. I sit and Google stuff. I vet their answer. I cross them with that. I find in time stuff. Be familiar with the documents produced by the defendant so you can grab other stuff. The other thing is, so I have all the documents. Let's say I choose 30, 40 exhibits I think are important. The deponent starts talking about something else. I open my server on another screen. I start finding it. I say, what bait stamp is that? Boom, I find it. I have it right in front of them. I do it, and I got it ready to go. All exhibits in the folder are put all the exhibits in a folder on a Google Drive. It's easy to give to the court reporter. I mentioned that. And then I also talked about the share folder that I use in some cases. Most of the time, I used a share folder where I give the other side the exhibits. Now, here's the question for you. Do you highlight the exhibits before or not? I am of two minds. I do it both ways. So especially at the beginning of the pandemic, before I was really used to this, I would have a set of exhibits that were the clean version. Then I'd have a set of exhibits where I've highlighted them so I know what to ask, okay? It used to be that I have them on paper and I do my circles and all my stuff, however you all do it. But so do you want to have a set of clean and dirty exhibits, so to say, but the more I do it, I'm like, you know what, I'm not that brilliant. They're going to kind of know what I'm going to ask anyway. So why don't I just show them the highlighter ones? Who cares, right? So I go both ways on that. So let me give you an example of this also. And I think this is the thing I was showing you before. So if you see this now, so this is my highlighted ones. These are the ones that I've highlighted. I'm going to show you them in a minute. But I also have, if you go up in my thing, these are the exhibits that I have that are clean. And then I have a file called Gary's highlighted version. So I can open them up together. So I can have the drug policy of the defendant clean, or I can have it, or I'll show you a couple of these other ones that I have. And now I'm opening up a different file folder because that was my opening my files on my X drive. Now I'm going to open my PDFs that I have all ready to go for you because I've already gotten I'm ready for this depo that I'm doing right now. I'm pretending right with you guys, right? So I have them. So now I have exhibit 4. So now I'm going to go to this exhibit 4, of course, that I was already on it. So I'm going to go over. This is a different exhibit. It was exhibit 5. This is a different case. It's a truck crash case with my deceased client. Very sad case. So here's their drug policy. And you can guess why I needed that for this case. Because of the driver was stoned at the time of this crash. So then I have this highlighted already, and this is highlighted ready to go. And for this depo, I showed the guy this version because the guy I was deposing was a pro. He was their pro testifier. He knew, he wrote this policy. I wasn't going to get anywhere with highlighting or not highlighting. Who cares? So then I say, isn't it true that the alcohol or drug use by employees, whether on or off the job, is a very unacceptable risk? Isn't that true? And he says, yes, blah, blah, blah. And then I can go to my next one, which is, if I open this in a bigger screen for myself, I can see it, because then I have the picture of this guy, this champion. And I can go, this is a picture from this guy's Facebook page. This is a public Facebook page where he's got this is a picture. So you read that, and then I flip over to this exhibit, say, were you friends with this guy on Facebook? Did you know he did this kind of stuff on Facebook? This is your long-term employee, and you have this policy. And then he says, well, you know, yeah, we had drug tested him a bunch of times. Okay, well, here's his, and then here's his entire employment file. Oh, it's in his employment file. Well, here's the whole 15 pages of it for this guy who's worked for you for 15 years. Show me in here where this is. And I sit and I scroll through with him, and he's looking at, nope, it's not on here. You're right. Hey, you know what, sir, though, we fired him because he violated our rules. Oh yeah, where's that? It's in his employment file. Here it is again. Let me show you. Where is that in here? Oh, it's not in here. Okay. All right. We drug tested him 15 years over this time period. Well, I have his employment file here. I only see 2. Oh yeah. Well, we didn't keep them all. Okay. That's fine. So those are some of the kinds of things you use. So you can either use either you can show them the highlighted or not. Now I also have cases where if I have a case where I have 10,000 pages produced to me, and I'm deposing the designee, I'm going to talk to them about policies and stuff, I don't want them to know. So what I will do is I will use a blank, a PDF with them that is not highlighted. I'll have my highlighted version on a screen right next to me, and then I'll highlight during the deposition and say, isn't it true that you have a national uniform policy where you decide to do blah, blah, blah. And then they're looking at the screen, they see it highlighted with them while they're looking at it. And it's really hard to twist away from that. And most of the time they'll say yes. So that's the way it's better. So I'm continuing on through my PowerPoint that I am now again sharing with you. Pull documents from the defendant's production to show them the witness by screen share. Remember, it doesn't have to be an exhibit. You don't have to have it pre-marked. You can pull random documents. You can pull articles off the internet. And then if they don't know anything about it, then it's not an exhibit. But if they do, then you mark it and then you authenticate it and then you get foundation. It's just like with a photograph. You know, do you recognize this photograph? No. Well, then you're not going to use it in that trial. But if they say yes, then you got foundation and you can start using it. Mark and use the designee deposition notice to inquire about witness. I use designee notices a lot. You mark it, you take them through subject matter, subject matter, subject matter. You keep going, you go through it. And I already told you about this. A truck case where I showed nothing. There was nothing in a 15-page employment pile about his termination or drug tests. How different is it? Record the depo. I already talked to you about this. I record it. It's absolutely awesome. And the other thing is witnesses know they're being recorded. They see themselves. I'm looking at myself right now and I can see myself. It's harder to play games. It's harder to lie. I find that one of the other ways is different. I get more admissions from people because they're looking at themselves on a screen and they're like, oh, I'm, you know, or they're rolling their eyes. Boy, I'm going to look like, oh boy, I can't really, I know my lawyer told me to say this, but he's showing me this document. What am I supposed to say? So I find that I get witnesses admitting even more. I'm getting them to admit liability in crash cases, policy violations. I have a local jail case. I took the head of the guy. I don't want to talk about it that much because it's in litigation. We're going to maybe go to trial in a few months. But I was sitting here showing him reports and showing him stuff. I got a lot of admissions from him because it was right there in front of him, and he had his professional reputation at stake. Witnesses can look really bad lying and when they're playing games, and you see it in real time. Hopefully it's not your client, but you do see this in real time. You can see them doing it. Watch out for your facial expressions too. I can be really bad about that. If I think someone is playing games, I'm like, I don't want to roll my eyes right in front of you, buddy. I try not to, but I've had other lawyers tell me stop smirking or whatever. So remember that too. Remember that you're being recorded too. And if you play this later, remember at trial, if you're trying a case, getting those admissions where the jury is looking at the witness and they look at you, and if you're kind of stone-faced and you expect this response, it can be very effective. So keep that in mind too. And you can see yourself. It takes some practice. How different is it? You can do it from anywhere. So I had a Columbia, Missouri deposition, and I was going to go drive to. It's going to be one of my first live ones in a while. And I ended up changing my plans. I wanted to go visit my son in college, and I went down to New Orleans, and I got on. I was all stressed about it. I put everything on my laptop. I got a conference room down at this hotel. I go in there, and I'm taking it. Well, guess what? My Wi-Fi was great. Their Wi-Fi was terrible. And I used a national reporting company, and they were there. And I keep telling them, like, you know, I keep getting these error messages. I said, who's Brandy or something? She's like, it's me. I say, what's going on? She said, well, this hotel's Wi-Fi is terrible. So it's kind of ironic, right? But you can do the deposition from anywhere. I do some at my home. I kind of work part-time in my office, kind of some days in, sometimes out, some days out, because we're trying to stagger shifts, stagger people working. But sometimes if I have a lot of documents and I know I'm going to be shifting a lot of stuff, I like to have my office set up where I am right now. Like today's for this CLE, I'm like, I'm not going to do this from my laptop because I want to screen share and I want to be able to do stuff, and I'm just more comfortable on a desktop. So get your comfort level up. I did a Zoom presentation for USA&M around Thanksgiving last fall. And I did it from I was traveling, and for Thanksgiving, and I did it from a room in my in-laws' house. It was great, and that was on Zoom stuff too, so it was perfect. So there you go. How different? So let's talk about some tricks that I have, and some of these I've already given you some tricks. So I put my notes in a Word document in front of me on a screen. I've had a number of oral arguments in different courts too. I put those in front of me too. So it looks like I'm looking at you, and it looks like I'm conscious and present with you, but no offense, I'm not. I'm looking at my notes. I'm reading a quote from a case. I'm doing different stuff with that material, and I find that to be very effective. I put docs in front of them. The other thing is I do, all right, so here's the other thing you do, is I quote language from documents, but I don't tell the other side that I'm doing it. I do this all the time. I pull up a document on a policy. Isn't it true that you guys believe that that getting keys or radios or handcuffs are an important part of your job duties? And then they say, oh, I don't know. Or they say yes. So I will read, or you read things from medical records, or you read policy language. You read it to them, see if they agree. You get them to agree or not agree. If they don't agree, then boom, you screen share and it shows the exact, and then you highlight it and you read it, you ask the question again, and then they agreed to you. You do that with them too. You do that with a witness 2 or 3 times. they're not going to stray from you again because they're going to think that you're reading stuff from them, reading stuff. So I've done this many times on policies. Isn't it true your policy is this? And their lawyer doesn't want them to say that. And they may squiggle around a little bit, but then you show them and you highlight it. I do it from police report. I have a couple examples in this. I'm not going to talk about them in this presentation, but in the materials I shared, I have a couple combos I put together of how to catch someone lying and that I did. And then I have another one about how to talk to someone about taking responsibility, especially when their lawyer doesn't want them to, about taking responsibility for a rear end car crash case. And I have some excerpts. I put them together. Those can be very effective. Medical records. You'll sit there and you'll read from a medical record. The deponent doesn't know you are, and it can be very effective, probably very effective, even more effective for a defense lawyer. That's typically what they do. So there you go. All right. Problems with it. You're on mute. Everybody gets that, right? You're on mute. Bad connectivity can rise at any time. Prep your client on Zoom as a test run the day before. Don't have them do Zoom the first time when you're ready to do the important depo. People can think just on Zoom is not real. Deal with that in your prep. Tell your client, listen, I know we're just going to be on a TV screen, but this is like you're in a witness stand with 12 jurors and a judge in a robe in front of you. That's what you got to do. You can have props too, by the way. You can have props. Like, look at this. I got a trophy. I have my trophy here. This is my mom's on this, I think. This is my mom getting in the SLU Hall of Fame. I have this, her little plaque here that I keep in my office to remember to have my mom always watching me, make sure I behave. I still need it at age 54. Your client may not look good on Zoom. Deal with that in the prep. What if their camera's like this the whole time, right? You want to get them, you want to get their camera right. You want to get their noise right. You want to get their lighting right. What if it's all black? Is the deponent using notes on their screen? You may not know it. No. Is the lawyer texting? I don't know. So if you look, so I have the two examples. I caught a deponent, I think lying. I have a cut of some stuff. I can give anybody the whole transcript if you want about what his story was versus what he told the police report. It was very different. And that is in the materials you have. I have one, we run into this all the time where are you taking responsibility for this accident? Did you rear end my client? And so that's always a tricky area. What can you, is that a conclusion that the jury's going to reach? Is the judge going to sustain that objection? I have an example of that in the materials in that shared drive of how to get around that I think I do it successfully 9 times out of 10, because either they're going to admit it or not. And most judges are going to let, you can't take the decision out of the jury's hands, but you also can find out, are they taking responsibility or not, or who else is at fault? What are you trying to say? All right, let me turn to mediation now. Let me do some questions here real quick. Do people ever object to doing Zoom depos? I'm having this fight in several cases right now. Dave, I had this fight in the beginning, and now I haven't had this fight at all recently, because I just want to do Zoom depos. And I tell the other side, listen, no offense, but I don't want to be around you. I happen to, whether or not you're vaccinated and all this, you don't know what's going on in that other room. And I do. I haven't had the fight in a while, but I do. I think there is a standing St. Louis County order. It depends on the court, but the level of whether you can do a Zoom depo or you have to be live can vary widely. I mean, if you're in, some courts have never shut down. Some courts are still not going to open. So, and I'll leave it to you, David, whether to file a motion with it. I think I would, I'm also like, don't flatter yourself. If you think you being in that room and your brilliant question is going to change the outcome of the case, it's like, don't flatter yourself, right? All right. Let's see. The next, do court reporters, Steve asked, do court reporters require to use their video services if you choose to record? So I had this yesterday, Steve. Great question. So I was prepping, and here's a Zoom trick for you. I prepped a client yesterday, older lady, very sweet. She forgot all kinds of stuff. She was going to be bad. And I decided 2 days ago, that after my prep on Zoom, that on paper, she would look a lot worse than she looked on video, because on video I could see she was confused and she didn't get it. But if you don't get that on a paper, on a transcript, you don't understand that. So what I did is at the end of the day, or that morning, I cross-noticed it. It was a depo of my client. I cross-noticed it. I said it was by Zoom. I said I was going to record it. We contacted the court reporter. It was at Alaris. I've used Alaris before, and they require you to use, if you're going to record with them, they have a policy. We're going to require you to record it with me. We're going to charge you for a videographer and all that. I said, fine, use my Zoom link. The court reporter was very understanding. We switched Zoom links to mine. I recorded the depo on mine, and I gave the other side. So that's a way you can do it, Steve, is flip it. Use your link, you record it and give it to them. And my experience yesterday was that they had no problem with that. All right, and in case you didn't hear at the beginning, folks, if you have a question you'd like to ask, please do it in the chat and I'm happy to ask. I'm running, as I always am, I'm running late on my time. So I'm going to, excuse me. I'm going to go back to sharing my screen. All right, mediation. This is, I found mediation in Zoom to be just as effective as in person. So here's the same basics go with depositions. Don't have the client in the same room with you and have a bunch of masks on. I feel that the people can't hear as well, and then you're in a room with your client, and everybody's just as stressed about Corona. The point of doing this is you're in a room by yourself and you don't have to worry about it. I also had, we had a mediation with a client who was deaf and became deaf because of alleged malpractice, and she had to be in a room. We were with one of our lawyers and we were typing for her. But other than that, but I had to redo. I talked at the beginning a little bit about how you have to redo your business to accommodate Corona and Zoom. I had to redo my whole paradigm for doing mediations, and I did it, and I trained my all the lawyers on it, and we did it a whole different. We made it very regimented. So we've done a lot of these. I've done a lot of these mediations. I've had one unsuccessful mediation, and the case might still settle. Every single one has been successful. So let me talk to you about what my process is. And these are steps from an internal Berger law, this is the memo that goes to all my staff and everybody that works with me, and me. It's for me too, and for everybody that works with me. This is what we do. We start out earlier. We schedule the mediation. We clear it with our clients. We clear everything. Some of this is basic. Most mediators schedule on their websites. You can find availability for mediators. You don't have to call up. You can get online and figure out and block time. It's very convenient. At the time of scheduling, we send a pre-mediation email to our client that tells our client what mediation is. They say in running a business, if you got to say the same thing 3 or 4 times, record it and give it as a video, or write it down and send it to them. So I found in my mediation preps, I say the same thing all over to everybody, what a mediation is. So I have a 2-page email that says everything I would say. I do the same thing for my deposition prep with my clients. I have a series of 3 videos that I do for my clients, which preps them for depositions. And then by the time I'm doing the depo prep, the basics are out of the way. Have a call with the client explaining mediation, discuss what it means. And then the other thing you do too, though, is you should start talking about numbers and expectations of your client before the mediation. Because one of the differences I find, so mediation, the client's in a little bit of a hot box. They got to decide whether or not to settle or not. That sometimes can be, you may be finding a lot of inertia that day in front of a screen. It's better to start with that 2 weeks before or a week before, saying, listen, I know you think your case is worth X amount, but you know what? They may not only offer this at the mediation. Or what are your liens? Let's talk about your liens. So I find that spending the time for the, and I used to do most of that just in that mediation session that day, because I was with the client for 6-8 hours that day, and that was effective. I find now that it's better to start before, to get their expectations ready, to start talking about the reality of some of this. So you're not moving them so much if you need to move them. I do the same thing with the defendant. I send them my mediation letter. I always send my mediation letter, not only to the mediator, but to the other side. And I always do it a week to 2 weeks before, because the defendant needs to get it, digest it. They need to send it up the chain for their committees and everybody else when they're getting authority, if you want to settle the case. And if I want to settle the case, I want to do that. So there you go. At the time of scheduling, I already did this one. Within a week of scheduling the mediation, get the numbers down, know what the liens are. I see other mediators on this call. I've had them tell me stories like there's a lawyer who's never even thought about the liens. I mean, are you kidding me? Let's because that's not going to happen during that mediation, because these lien holders anyway. So this is about some of the, I have a whole CLE I've done on lien reduction. I did it last May. It's on my website. It's on my lawyer to lawyer page on my website if you ever want to know about that. Within a week, make sure you have everything supplemented. You don't want to be in a mediation and have your client say, oh yeah, I saw the doctor last week and I needed another revision surgery. You don't want that. Is all the medical related? What is the other side going to throw at you that you need to be ready for? What curveballs do you need to accommodate? 2 weeks before the mediation, you guys can read this. I'm running out of time. Let me show you something that I think is my best trick. So I attached 3 mediation letters to the materials from 3 different cases of mediation letters that I did in real time, and it worked. Those cases all settled. Those are the letters that I sent to the other side. Here's, I think, the bet. I do this mediation working notes, and here's some examples. So these are notes. You guys have this PowerPoint. You can look at them in more detail. So I create a Word document. I create a Word document during the mediation that I use, and I share screen with my clients because I can't be in the room talking to them. So I'll share the offers. They're offering this. They're offering this, we're demanding this. Here's the numbers, here there's going. Here's your liens. Here's what I'm going to reduce them to. Here's the good key points about the case. Here's how we're going to get around them. Here's my attorney's fee, and here's what you're getting in your pocket, because that's what every client wants to know. So let me fly through these real quick for you. Then we're going to take a break, a 5-minute break, and then my able lawyers, who I'm so lucky to have, Tyler and Jen, working with me. They're going to do this next CLE. So you see at the top, I have demands and offers. Here's some conditions that they put in. This document gets generated in real time. I don't prepare this. I'm typing stuff. I'm doing this. Here's your billed and old medical. The defendant says that the paid is this. I had it a little bit different. Here's your wage loss. And I start having notes about this. Pain and suffering, we have a lot of that, but what about open and obvious in this case? That's a problem. Then here's what I did in this case. I literally cut and pasted the defendant's report. They had an IME with their, and I literally had it up on my screen, and I cut and pasted it over to this document, and I started highlighting it. And I use this document with both my client, and I use it with the mediator. So I showed this all to the mediator, and I highlighted this to show, hey, the defendant's IME report helps me in spades. It's amazing. And the mediator said, send that to me. So then I also emailed it to the mediator. They showed it to the other side. We settled the case. So then here's my breakdown. I usually do this because the client wants to know what they're getting at. So here's where we can, if we settle at these different levels, here's what you're getting in your pocket. And some of these are subject to how the liens go. I show my client, I'm transparent. I show my client my expenses. I know what they are. So there's one. Here's another one I did in another case. Demands and offers. Here's the settlement at different levels. Here's what my fee is. Here's what you're getting. Here's the liens. folks. You want to know about liens? Here's the liens that you got. Let's talk about this, because liens are part of settling a case. In this mediation, I had the lien holder in the mediation. Some of the I've had lien holders in mediations as well, if it's a work comp lien or something like that, if it's big. Here is a chart of my billed versus paid. And then here's my notes. Our guy did here, the defendant says, like, the mediator comes in and says, hey, this is what the defendants say. And then I say, well, here's my responses. I'm going to show you that again in a minute. Mediation notes. These are notes in a wage and hour case I mediated successfully. Here's what my client's damages were. Then I have this. This is a little thing I had. This was about some of the issues in the case. And this is a Fair Labor Standard Act case that we mediated. We do a lot of car wrecks, med mals. We do a lot of wage and hour stuff. We try to keep ourselves busy and other stuff and a variety of stuff just so we can have fun. So here's a nursing home case. Here, so the mediator came in and said, hey man, here's all the defenses in the case. And so I put I listed them out in 5 things. And then over about a half hour, I figured out my responses and I was looking at notes and stuff. And I did that. I did it in another color. And then I showed the mediator and my clients. They knew I was working, not just sitting around during this mediation. And this is, look, I think this is totally editorial. I think these defenses are weak. If they're talking about this, they're not talking about liability. We got them. Let's get paid in this case. And then I literally opened a depo in PDF because there was a point at issue in the case. I cut and pasted from the PDF some of the testimony. I moved it over to my Word document. I shared screen with the mediator, and I called BS on one of the points the other side was making. So that's one thing I did. All right, everybody, listen, have fun with this stuff. Thanks for attending this. Have fun with this. I truly, anytime that, change, the only thing that's always constant in life is change, right? And so the more you surrender to that, and in your business and in practicing law, the happier you will be. So if you surrender to that idea, embrace the change, judo it, double down on it. I never have it, I talk to my other lawyers who work with me, I say, we try to systematize this stuff, but every case is different and every case changes. You think a case is this and it changes. So just like with changing in a case, embrace the change, figure it out, use it to your advantage, have the surrender to that idea and have fun with it. I strongly recommend that. So I'm going to look at my chat real quick. Oh, a couple of things. One is I'll always answer questions for free and talk to any lawyers. So if you guys have questions about this, how do you do this, Gary? Blah, blah, blah. If you want to get a doctor's depo by Zoom or anything else from me, email us. We'll send you all this stuff, some of the stuff we do. And then I got 2 questions before I'm done. Is it true the deponent must always be on the screen while recording? You'd like them to be. Sometimes people leave. You never know. You never know what people do. You pin the video to them. But then again, there's nothing better than asking a question and getting the witness to get up and leave the screen. It can be very effective. Make sure you record that and make sure you play that for the jury. And next question, is it true that the deponent, are you signing the release at the Zoom mediation? Are you comfortable with typed signatures? I am, but I wonder about other practitioners. I do sign. So most mediation places have a memorandum where you confirm the settlement. So I sign those during the mediation. Most mediators don't end the Zoom until that's done, probably because they've learned that lesson the hard way. And so on Adobe, which is what I use, it's very easy to sign. I get authority from my client to sign, or I show my client how to do it and they sign too. So I am very comfortable with electronic signatures. I exclusively do it. I do it for my representation agreements. HIPAA, medical authorizations can be tough. Sometimes they don't let you have them unless you have the original, but 99% of it, I sign everything electronically. And then typically, the other side is going to have 2 weeks to send you a release. If it's lawyers that I know a lot and they know what they're doing, a lot of times the other side has the release ready to go, and we are literally doing that, because sometimes too in mediation, remember, I argue a lot about confidentiality sometimes because I'm not as easy about that as sometimes other people are. So sometimes we're haggling over confidentiality at the end. I say, show me your confidentiality, share screen with me or email it to me, and we hash it out, we get it done. And I think that, and hopefully one of the things that does change because of the pandemic, two things, as I love Zoom. Secondly is I hope we go to electronic signatures. Here's another question from Steve. Respect to mediation, does Medicare settle before they even know the settlement amount? That's a whole nother CLE, Steve. I can't do Medicare. So on get your conditional payment letter and your conditional amount before you go to the mediation on Medicare and Medicaid. We subscribe to their portal. Ask them for reduction, but it is true. Most of the time, they're not going to give you that good reduction unless you tell them the final terms, and then you just protect and indemnify for the other side, and then you cut the deal on the settlement, and then you work with Medicare, and then hopefully by the time the checks are cut and stuff, the other side knows what the lien is. Most defense lawyers I work with trust me to write the Medicare check. But if they don't, I say, that's fine, I don't care. Here's the amount and do it. As long as you're moving the release forward, getting the release to the other side, sometimes those lien things trickle in. That's why it's so important to start liens and start thinking about mediation early. Okay, everybody, of course I went over time. Let's take 5 minutes. Hopefully I'm gonna mute myself and stop my video, and then we're gonna start, and Tyler and Genevieve are gonna start their presentation. Thank you very much.
Hey everybody, this is Genevieve, attorney at Berger Law, and thought I would follow up after Gary on some demand letter suggestions and negotiation tricks. Hopefully I've learned from his presentation and I'm not on mute and y'all can hear me. So hopefully someone will let me know if there's any problem with that. So I thought I would get started now. I have a presentation as well on this. So I'm going to start my screen share. All right. Okay. All right. Let me get this up real quick. Okay. So demand letters, they're important. This is how law firms make money. You settle cases by turning the cases over, getting those settlements. And so you really want to get your demand out as soon as you possibly can while still making it effective, persuasive, and detailed enough to get a great result. You can drastically add value to any case depending on the quality of the demand letter. And it's easy to fall into routines and templates when doing these, but with just a little bit of extra effort and awareness on things to highlight, it can make a really big difference in your case. Pre-litigation demands are your opportunity to favorably present your claim in the best light possible before any negative information can come out in discovery. So if you can settle the case without having to file a lawsuit for a good amount, that's definitely ideal. And, you know, the insurance companies are not going to just make an offer or throw money at you without one. So definitely get those demand letters out. So something that seems obvious, but really requires a lot of focus is to highlight the positive and leave out the negative and don't overly rely on those templates. Every case and every claim you have is a little bit different. You may have a case that has very low property damage, but bad injuries, or the opposite, where you have a case where a car is completely demolished, but you don't have any positive findings on imaging or MRIs. And so you want to tailor your demands that really hit on the good things and leave out the negative, because you can do that before litigation. And so it's important to try to get the car damage photos at the very beginning of the case with the intake, because the photos are very persuasive. You can imagine putting them in front of a jury. If you see a car that's completely totaled, then it's hard not to imagine someone would be hurt. And then on the flip side, if there's not a lot of damage, that could be more of a challenge down the road. So if you have good photos of the car damage, obviously send them with a demand, make sure they're included, and reference that the car is totaled in your letter. Then on the flip side, you don't have to send photos just because you have them. If the photos don't help you, don't send them. And sometimes it's a little mix of the two. I've had clients who are driving, big pickup trucks that have no damage at all, but the car that hit them is demolished. And in those cases, sometimes I still just send the picture of the demolished car. You want to get your adjuster's attention right away in your demand letter. And so if your client had surgery, I include that in the very first sentence. So they know, they're in that mindset, all right, this is a big case. Again, with MRIs, positive MRI findings like disc herniations, labral tears, annular tears, all of those will add significant value to the case. And so you want to make sure that you explain those in detail in the demand letter if it's going to help you. Now, on the flip side, pretty much every client I've had goes to the ER and has a negative x-ray, because x-rays don't show tears, and if they don't have a fracture, they're going to be negative. Sometimes the x-rays or the MRIs show horrible degeneration or pre-existing issues. These x-rays and MRIs are still compensable if it was reasonable to have them done because of the car accident. So you definitely want and need to include them and include the bills. But you want to make sure if your legal assistant is helping you or doing the first draft of the demand, you don't need to sit and summarize all the negative findings that are in those x-rays. Kind of, just mention they got an MRI of their neck, and you don't have to go into the detail of the negatives. Something I'm going to talk about a little bit more are cases where your client complains of headaches. Concussion and head injury cases have their own challenges, but also can be turned into very high value cases if highlighted the correct way. And so I'll get to that in a bit. A problem that often comes up that can affect the value of cases are when your client has a gap in treatment. Depending on what the situation is, I handle that differently. If there's not really a good explanation for it, just try to gloss over it. A lot of times if you're summarizing medical, you can get in the habit of saying, on January 1st, they went to the hospital. On January 15th, they went to the chiropractor. But then if they didn't get an MRI until, October of, several months later, instead of really highlighting that gap, just say subsequently they got an MRI. And it's a small thing, but it just can help keep the adjuster's radar off of those things to dig into more. Because some adjusters are more thorough than others, and some will just go off of what you tell them. And that's your opportunity to shape it in the best way possible. So on the other hand, sometimes there's some really legitimate reasons for gaps in treatment, like COVID, where, chiropractors weren't seeing people in person, elective surgeries weren't happening. If it's a situation like that, then sometimes I want to confront it head on and include that in the letter. And so if you come across a gap like that, be sure and talk to your client and find out why that is. And that can help, overcome an obstacle that you otherwise would have trouble with. I had a client who had injuries to his kidneys, so he couldn't get chiropractic care. So in those cases, we mention that when they ask why there's a gap. Other sort of things that add value to the case are if there's a commercial vehicle involved, there's more insurance, it's a defendant, the juries know there's insurance. If there's a semi-truck, those are usually, big accidents. Mention that in one of the first sentences. If the accident happened at highway speeds, it, typically adds more value. On the flip side, we've all had those parking lot cases too. And sometimes the parking lot cases have big impacts or bad injuries, but I tend to gloss over that as well and don't necessarily mention the parking lot because, it can just give an impression to the adjuster already that it's a low impact case. You'll see in the medical record sometimes where a client says, I was hit at 50 miles an hour, or I was going 10 miles an hour. Obviously use your judgment and include the high speed if it helps, or just leave out the low speed if it doesn't. If you have that rare client who has no prior injuries and they're young, mention that, particularly when you have these neck and back injuries that aren't able to be treated with surgery, or they're too young for surgery and they just have to suffer with what they're going through and have chiropractic care and injections. Point that out. That's helpful. And then, again, not to state the obvious, don't highlight if your client is 90 years old or has all these prior problems. Assistants or other people can be summarizing medical records and just sort of include that information, which is not necessary at this stage in the case. One other thing that is important to include to really add value, and I'll go over an example of this in a minute, is including estimates of future care. Sometimes your client is still treating or will need treatment in the future. Perhaps they have been recommended that they could get a surgery on their shoulder or their knee, but they aren't sure if they really want to do it. Include that cost of the future care, the estimates of the surgery. Make sure you include future lost wages if they have the surgery. And all of that can just bump up your specials, even if you don't have something concrete right then. And then finally, look to any other special things in your case. If the defendant got a DUI or was ticketed, if your client was taken by ambulance or helivac, use descriptive language and bring out the best parts of your case so that you can send that good impression from the beginning. Here's an example of a case that we had where our client only had $4,552 in bills, yet we were able to settle the case for $90,000. And that was by highlighting the positive and leaving out the negative. This was his property damage, so we didn't send that picture. But he did have a labral tear in his shoulder, which is obviously a positive objective finding on an MRI and adds a lot of value to the case. But at the same time, he didn't have much treatment for it at all. He did have a orthopedic who said that if he wanted surgery, he could get it. And so that's something that I jumped all over. And I actually included the estimates of the surgery in the demand letter itself with all the other specials. And if you're looking at, where did I get these random numbers for the future labral repair and the anesthesia and the PT, I had another client who did have those surgeries, and those were her exact billing numbers. So I put those in there as an estimate. And then now you've sort of increased the specials from 4,500 to 52,000 just by that. And can you get called out on it? Maybe, but it really worked in this case. Once you're in litigation, you need an expert to say that the surgery is reasonably certain. At this point, if you do your demand letter quickly, and 3 years haven't gone by since the accident, the adjuster is more likely to try to settle the case before they have the surgery. They can't use that gap in treatment argument against you. So it's another reason why you want to get it out quickly. And additionally, I added a range of future lost wages after the surgery of 3 to 6 months. And overall, that added a lot of value to this case that had a bad injury, but low property damage and low bills. I wanted to talk about head injury cases as well, because this is where you can turn a small case into a much larger case. So the first step is just to see if your client ever even complained of headaches. Sometimes your clients don't even really focus on that aspect, but they might have hit their head on the windshield, on the steering wheel, or just had bad whiplash that's sufficient to cause a concussion. And a concussion technically is a traumatic brain injury. And so I use that language again in the first sentence of the letter to get the adjuster's attention and say my client suffered a traumatic brain injury. If there's suspicion of concussion and we can get some medical evidence to back that up. Otherwise, adjusters tend to make low offers on head injury cases because there's no objective evidence of injury. Usually the CTs are negative. If they weren't, they would have a brain hemorrhage, which is something entirely different. They aren't, getting treatment every week like you would for a chiropractor, so the bills may be low. And then insurance adjusters will disregard a client's subjective complaints of memory loss. So if you can, suspect a concussion, have the client see a neurologist for an official diagnosis to obtain cognitive rehabilitation, which could include eye movement therapy, there's memory exercises, different things like that. It helps validate the client's subjective complaints and increases the medical specials. And, even more than that, it gives your client the treatment that they need so they can be followed, because these head injuries are serious and have been sort of neglected over time. And now it's come to light how bad these head injuries can be in the future. So if you have one, or a client who has one, you really want to highlight that, get a neurologist, and add value to the case. And then in the demand letter, you need to emphasize it too. And so I actually put in there about how we've learned more from the head injuries with the NFL, and how thus far they've paid out 1 billion cases to eligible players and families on head injury cases. Because if there's one thing that insurance companies care about, it's money. And so that way, it catches their attention. And then for head injury cases, I like to spend a little extra time personalizing in the demand the impact that it has on their everyday life. Whether it's sometimes there's somebody who's in school or working as a nurse, it affects being able to take care of their kids. All of those things can really, add more to a case to counteract the adjuster's arguments about there being low bills or not enough treatment or subjective complaints. Turning to a little bit more boring of a topic, but very necessary, you really need to make sure that you or your paralegal obtains all the medical charges. And obviously, the higher the bills, the higher the settlement. You want to make sure you get everything. And you don't want your client on the hook for unknown outstanding balances or liens. So it seems obvious, but we all know it's easier said than done. And you can't always just rely on your client to know all of their treaters. They forget a lot of times. They don't really know that an imaging facility is separate from the doctor who sent them there, or that the physicians bill separately, things like that. And so I'm sure most people have systems already to get those records and bills, but be sure to follow up and make sure that you have them and are getting them. And something that helps is to get updated billing itemizations if there's any liens, such as an Optum health insurance lien, Medicare itemizations, explanation of benefits, MedPay reports, client documents. Cross-reference all of these before finalizing and drafting your demand, just to double check that you've gotten everybody. And further, it can be a shortcut to find out what those charges are if your client is still treating or if you're waiting on records. I know that a lot of times, you have a general system in place with your legal assistants where you send the client to treatment, they finish treating, you order their records and bills, then you drop the demand. But a lot of times these record requests will get held up. Maybe they need a different HIPAA, or they switched to SIOX, or have a different method of getting that. And so there might be just one facility or one charge that you're missing, and you don't want that to hold up sending out your entire demand. And so if you're missing one of those charges, call the facility and just ask for the charges, even if you don't have the bill yet, or cross-reference those other things I mentioned. I can usually get an updated Optum itemization within 24 hours and find out, what those PT bills are, even though I'm still waiting on the bills themselves. That way you can at least send the demand and include that and know what your client's case is worth. You can always supplement the actual bills later. Another thing that seems obvious, but at least read or glance at the bills. Do they cover all the dates of treatment? I can look at something right away and know it's wrong because, it's not including the injections, or the MRIs are missing, or they seem too low. So just take, a couple extra 5 minutes to glance at these and see if they're related and make sense. And so another thing too, to tell your paralegals or to look out for yourself, are references to other medical treaters and the records that you do have. Sometimes your primary care records might mention a neurologist or the other way around. So although this is sort of tedious, it's important. And, one of the main takeaways here through all of this is you want to get these demand letters out quickly. And there's more than one way to figure out what the charges are if you don't have the bill itself or if you're waiting on it. Another thing too, just in generally, you want to balance efficiency with detail on these demand letters because, again, every case is a little bit different. Gary says this a lot. Don't let perfect be the enemy of good. You can supplement the demand letters. You want to hit the good stuff. You don't need to summarize every single, chiropractic straight leg raising test that was performed. And you need to assess the case and see what will be best given the particular circumstances you have. Generally, you want more detailed demands for bigger cases to emphasize the extent of injuries, the length of treatment, the pain and suffering, and less detailed demands for smaller cases. An exception to this is that you might have a big case that you can do a quick, short demand on because it's an easy policy limits case. So I know we're pretty familiar with this as well, but if there's significant injuries and not a lot of coverage, you don't need to wait for your client to be finished treating and to receive every single bill before getting that demand out there. Because if there's only $25,000 or $100,000 and that's all there is, you might as well get that process going. Prepare for an underinsured claim if you can, and not let ongoing treatment hold you up. So if your client fractured something, needs surgery, has one huge bill, or significant findings on imaging, send a short, quick, simple demand for the policy limits, even if your client's still treating or you're still waiting on records. You can always supplement if necessary. Communicate with your paralegal or legal assistant about this. Mine will let me know if we get a ER bill that's 30 grand. He'll tell me we just got this ER bill, and that's something to communicate because sometimes you do have that process again of when the client finishes treating, requests the bills, and they come in at different times. But just streamline it, go quicker if it's policy limits, and that can be very helpful. So to do that, also you need to find out what the policy limits are. Sometimes the adjuster won't want to tell you. And so a trick that's worked for me the vast majority of the time is to tell them that we have big injuries, an underinsured claim, and that the underinsured carrier won't approve any underlying settlement without the deck page and without the limits. And then a lot of times in those cases, they will give those to me. And that's helpful again. So you know what you're working with. If your client needs more care on a lien basis, if you can get the demand out quick, to try to get those policy limits as soon as you possibly can. And if they don't give them to you and you know your case is worth more than minimum coverage, sometimes you just have to demand $1 million or threaten suit. And I don't like to overly do this on a small case, but it's worked recently in a case I just had. This was a dog bite case. Our client was attacked by a bull mastiff and had plastic surgery. She had pretty high charges of 73 grand, but only had 17,900 paid owed. The adjuster refused to divulge the policy limits, and he was pretty annoying in general. So I told him, fine, I'm demanding $1 million. I sent a written demand for the $1 million, but this is very important. Discuss with your client in detail that their case is not worth that much so you can manage the expectations. And when I made that $1 million demand, it ended up escalating the case to an adjuster with higher settlement authority and enlarged the settlement reserves. Then, because it's potentially $1 million case, the insurance company suggested pre-litigation mediation, which was amazing and very helpful. The case settled for over $300,000 at this pre-litigation mediation very quickly. And so I, hadn't been sure about the $1 million demand at first. Gary's given me trouble for those before, but it ended up working out here. And then just another little tip, I copied and pasted graphic photos of the client's facial wounds from this attack in the body of the demand letter itself. She ended up having an amazing recovery with a barely noticeable scar. So I was worried about that on the mediation. I didn't necessarily want the adjuster to see that. So I actually asked that we not mediate face-to-face, and the adjuster didn't see how everything healed perfectly, which was helpful to me. And the mediator obviously saw my client. I'm assuming he didn't say anything, but just something to consider. And I know I'm going kind of quickly. I want to make sure that Tyler has time as well. So I just want to touch on bad faith demands real quick, because the bad faith template is a little bit different. It has requirements for it to be legitimate, but using this template has gotten me great results, even if I don't necessarily end up having a bad faith claim down the road. So, as you know, an insurance company operates in bad faith when they fail to pay a claim or make an offer within a reasonable time period. And if you can, show bad faith against them and get a verdict above the policy limits, then they can be on the hook for that. And insurance companies are very afraid of this. So just using the word bad faith in your demand seems to garner more of a response. So the statute 537-58 has the requirements. It needs to be written, must reference a statute, must send by certified mail, need an at least 90-day deadline, list the amount you're demanding, the date and location of loss, claim number, description of injuries, party or parties to be released, the claims that you're releasing, say that it's an offer of unconditional release for the liabilities insurers insured. This is a little bit different. List the names and addresses of all the healthcare providers and enclose HIPAA compliant authorizations. And if you're seeking lost wages, list the names and addresses of the claimant's employers so they can get those employment records. When I do these demand letters, I put all that information just in the top part of the caption. So it's just right there. It helps me know it's there. It gets the adjuster's attention, and it'd be good for evidence down the road if you use it. Right here, just, quotes of what to include. This is a demand pursuant to the statute. You want to confirm what the policy limits really are. And again, down here, mention that you believe it to be bad faith. Now, to be admissible as evidence, you need to have all these requirements included. And that's, again, if you go down the road. Sometimes I don't include the authorizations with the knowledge that it's not a fully compliant bad faith demand. But if I don't want the adjusters to have that full access to my client's whole medical history, then either do really narrow authorizations or not include them at that time, but know that down the road I could redo another bad faith demand that is 100% compliant. But the adjusters just see the caption, the template, the statute, and that in itself can be enough for them to get nervous. I mean, they ask me for extensions to respond, and I don't get that sort of reaction with regular demands. Then finally, also negotiations. There's no need for a COVID discount. Cases have still been settling for the same amounts as before or more. The adjuster's final top offer is never really their top offer, obviously, but I do say that to my client, that the adjuster said this is their top offer to manage their expectations, get good settlement authority, and surpass their expectations, but I can get just a little bit more. And then if I get to an impasse and the client doesn't want to file suit, or it's a smaller case, a lot of times we send a fake petition with a legitimate bottom line demand and 1 week deadline to respond. And that works the vast majority of the time to at least get them to their real top offer. And then mediation can be a great alternative to trials, as Gary's went over, though trials are returning. And finally, this is the last slide. reassess your case at every turn. You know, if you get a bad police report or bad medical records, or there's something not right, no property damage, look at your case and see if it's worth your time as a firm, or if it's something that you need to get rid of early, or possibly refer to someone else if it's just a smaller case. And with that, I'm going to finish my presentation and let Tyler go with his. And if there's any other questions at the end, then I can try to answer them at that time. All right. So I think there'll probably be just a real quick break to make sure Tyler gets set up, but thank you for listening today.
Okay, thank you, Gary. I appreciate that. And thank you, Genevieve. I appreciate that. Let me, I likewise have a PowerPoint presentation here, so let me set this to share my screen and we will get started on it. Okay, my portion of the presentation here I've titled Being Cooperative and Resolving Conflict. The good news for us during COVID is that insurance companies have not been relying on the pandemic and the difficulty in obtaining trial dates to simply refuse to discuss negotiation. I think there's two parts to that. I think first that adjusters, regardless of whether or not there's a pandemic going on, have a pretty good motivation from a management standpoint to continue to move their caseload and move forward and clear their cases so that they get more, more cases in. People are continuing to be injured, continuing to make claims, and so it's pushing that forward. And also, I think they want to avoid any accusations of either collusive behavior by insurance companies or accusations of bad faith or vexatious refusal to pay based on an argument that we're not going to pay out simply because there's a global pandemic going on and you can't force a trial date on us. So we want to be cooperative, though, in resolving conflict is my more generic title. My more novel title I stole from the excellent trash masterpiece Roadhouse. I want you to be nice until it's time to not be nice. And that's something we want to be cooperative. Usually when you're communicating with an adjuster, you're not actually directly asking them for the money, which although it sounds like you are, really the person that you're asking for money is either their supervisor or the panel of people above them that make the decisions about the money. So to the extent that you can, you really want to get the adjuster on your side because you're not directly making your case to the purse. The adjuster has to do that for you. And you want, as Genevieve discussed, you want to arm them with the tools necessary so that they can best make your case for you to the person that actually holds the purse strings. And that makes your job easier. And quite frankly, it makes their job easier, and it makes it easier for you to get better compensation for your client. You want to set up the demand to make the adjuster's job easier. Genevieve covered this in some excellent detail, I think, and so I don't need to belabor the point too much, but just the overall larger points of it is that what I like to do is I like to think about the things I like to do at work. What makes my job easier on a day-to-day basis? Do you want to sit and go through 5,000 pages of medical records that looks like it's been shuffled and then handed over to you? Or would you rather deal with an accurate summary of the situation and what's going on? Give them a summary. Give them highlights, highlight the good medical, make it easier when they go to their boss and they say, I need $100,000 to settle this case, make it easy for them to explain to their boss why that's the case. And finally, one last thing to think about is to just ask the adjuster what they're looking for. I've made a demand, you're at a ridiculously low number, I'd like you to come up, what do I need to do to allow you to come up? Ask them what they're looking for. To a large extent, this is a customer service driven business. And in a case like this, the adjuster is actually your customer. You're the one putting something together for them to allow them to do their job better. If I'm trying to make you a sandwich, my first question should be, what kind of sandwich would you like? If you want a Reuben and I start making you a tuna melt, it doesn't do you any good and it doesn't move your case any farther along. So you want to do what's necessary to make the adjuster's demand easier, make it easier for them to get the approval that they need to pay you money. Next, and Genevieve touched on this as well, but my silly joke about this is you want to know the limits on your insurance policy. Here's my joke. Know your limits, Master Wayne. Batman has no limits. Well, Batman might not have limits, but insurance companies do have limits. You want to know those limits. Typically, obviously, what we're dealing with is either 25, 50,000, 50, 100, 100, 300, 250, 500, and then sometimes on top of that, you also have an umbrella policy of $1 million or more. You want to know how big the potential pool of money is that you're dealing with. Obviously, that under most circumstances is the maximum recovery that you're likely going to get, and so you want to be aware of that. You want to be very aware of these minimum level policies. The $25,000, $50,000 policy is the minimum required by statute in both Missouri and Illinois. It's important to know this for a lot of the reasons that we've discussed already. You don't, if your client is getting treatment, they don't have health insurance, you don't want them to incur an extensive amount of medical bills that they will not be able to pay back or put them in a bad financial position when you're dealing with a minimum level policy. Additionally, you need less information to get a $25,000 settlement than you do $250,000. If I'm asking you for $25,000, typically I need to provide you with less information than I'm asking you for $250,000 or $500,000. Next important point, I sort of generically entitled insurance company attorneys. I have experience, I've worked in-house in an insurance company. Insurance company attorneys do not want any part of litigating a $25,000 policy if they can avoid it. Companies are exceedingly concerned with results in excess of the policy limit. An attorney is going to get much less criticism losing $95,000 on a $100,000 insurance policy at trial than they will losing $30,000 on a $25,000 level policy. Especially given the jurisdiction you're in, if you're in a favorable jurisdiction, if you're in the city of St. Louis, if you're in Madison County or St. Clair County, Illinois, and it's a favorable jurisdiction, any case that goes to trial has a significant risk, no matter what the medical bills are at issue, of a verdict in excess of that amount. And the adjusters and the attorneys will do everything they can to move these cases off their plate. So be aware of that. You can get a demand in quickly. You can often get a quick turnaround and a better result for your client, more compensation on these minimum level policies. And also you want to keep in mind uninsured or underinsured provisions on the policies. Uninsured coverage is required in Missouri and Illinois. Underinsured coverage is not always required, so you want to be aware of that. The underinsured on a $25,000, $50,000 minimum level policy in Missouri or in Illinois here. Missouri, it's governed by statute. The statute's 379-204. Those policies in Missouri, if the liability limit on the policy is less than twice the $25,000 minimum, that underinsured policy actually acts as excess coverage. So it may be an additional $25,000 you may be able to recover for your client in those kinds of circumstances. And again, it's not required in Missouri by statute. Illinois, it's a little bit more complicated. There's some interaction between the case law and the statutory authority as to how these policies are treated. 215 ILCS 5143A2 requires Illinois policies to have underinsured motorist coverage, but it exempts that requirement for minimum level policies. And some minimum level policies, though, do offer underinsured coverage. Now, we're arguing presently in a couple of cases now that is potentially fraudulent coverage, because either the $25,000 underinsured limit is going to get entirely offset by payments from another source, or it will be paid out as uninsured motorist coverage to get the Illinois driver up to the $25,000 minimum. So that's something to keep in mind if you have a case on an Illinois policy with a minimum level underinsured requirement. There's another complication in Missouri that can potentially arise for underinsured coverage on a $50,000 policy. The reasoning for that is, if you look at 379-204, it says any underinsured motor vehicle coverage with limits of liability less than 2 times the limits for bodily injury or death, so less than twice the $25,000, shall be construed to provide excess coverage. Now, on its face, a $50,000 policy would be exempt from this requirement and not excess coverage, because the limit of $50,000 is twice the minimum limit of $25,000. But then the question arises, is that the hard limit, or is it the limit that the insured can actually recover? Because these underinsured provisions always include an offset. So the attorney on the other side is going to say, well, judge, this is a $50,000 policy. It's twice that $25,000 limit. And you can counter with, but judge, my client will never recover the $50,000. So that's not the actual limit here. The actual limit is less than $50,000. Therefore, it's less than the 2 times $25,000 limit. Therefore, it should be excess coverage. So that's essentially the argument. And that kind of circular reasoning, you can argue that the policy is providing something in one hand, taking away in the other, therefore ambiguous, therefore it should be decided in the insured's favor. And I'm pointing these out not to raise just simply these specific instances or arguments in front of a judge, but to point out that you want to be aware of the particular provisions within your client's policy if you're making either an uninsured claim or an underinsured claim, because this type of language can be used to convince adjusters to increase an offer, or to convince an attorney on the other side to increase an offer. Some insurance companies will absolutely go to bat. They'll feel that they have a good case. They'll feel that they have a good argument, and they'll want to carry this all the way through. They'll tell you that they'll appeal it up to the Supreme Court if necessary. Other insurance companies don't want to risk a bad ruling that might impact all of their policies, and so they're willing to pay you and your client more money so that you don't press this particular issue, especially if it's something that they feel like would cost them a significant amount of money across the board. So that's something to be aware of that you can leverage in certain cases. If you have questionable language in an insurance policy, if you know your policy well and you know how to challenge an adjuster on the phrasing of the policy and raise these issues with them, you can get better compensation for your client. Now, a little further on with, if you need to make an underinsured claim, stick to it. And the joke I've used for this is probably the only line I can use from the film Bad Santa without getting fired. If you don't know the movie, the joke here is that 2 guys are trying to rob a department store. Bernie Mac here catches wind of it. He wants in on the deal, and he wants half. Well, he says half, and they counter with 20%. He says half. They counter with 25%. He sticks to half. He gets half. If you need to eventually make an underinsured claim, say the underlying driver has a $25,000 policy and your client has $50,000 in medical bills and a $100,000 underinsured policy, you need to recover every penny of that $25,000 in order to make that underinsured claim so that you can seek additional compensation for your client. Now, there's a couple of steps you want to make sure you follow with this. You want to notify the underinsured adjuster, so whoever your client's insurance is, whether it's State Farm or Allstate or whatever it may be, you want to notify that adjuster as soon as possible. And you can even go so far as to provide them with the materials they will need to evaluate your client's claim if you know such a claim is coming. We've done that very recently with a $25,000 underlying policy when we have an insured or we have a client that has over $100,000 in medical bills. We've notified the underinsured adjuster already. And I can't say every policy requires notice, but every policy I've ever seen requires the underinsured to be placed on notice of a settlement before you can make such a settlement. So you want to do that. You also want to notify the opposing counsel or the underlying adjuster as soon as possible. It's actually going to make it a lot easier for them to get you more money in settlement if you can say to them, we are absolutely not taking a penny less than limit. We had good luck with this in a case pretty recently. We had a young gentleman who was hurt pretty severely, lower back injury. He'd seen Dr. Gornett for a 2-level disc replacement. There was a $250,000 underlying policy, and then actually the highest underinsured policy I've ever seen of $1 million. And I called the adjuster up. She was from the East Coast. She was not familiar with Dr. Gornett. I explained to her the situation. I explained the client's injuries. I explained what the medical bills were. And I invited her actually to call any local counsel that she had in St. Louis that she knew to talk to her about Dr. Gornett. And I told her we weren't going to ever take a penny less than the $250,000 because in order to make sure our client was fully compensated, we needed the opportunity to go after that $1 million underinsured policy. She called me back about a week later and they tendered the $250,000. And so we were able to quickly get that recovery for our client and then move on to the next stage of getting him compensation. So it makes that easier for them to get approval if you have a credible demand on an underinsured case. It'll make it a lot quicker for them to say yes to something like that. And again, just remember, stick to the talk number. $99,999 is not going to get it done if you need $100,000 to make the claim. The next thing that you can look at to make these kinds of negotiations easier on yourself under these circumstances is the fancy tripartite relationship, which is simply the relationship between the defense attorney, the insurer or insurance company, and then the insured, which is usually defendant in our case. What I want you to focus on here is the insured or defendant. Typically, we think of this individual as the opposition, but under certain circumstances, you can get that person on your side. The question is, how can you get them on your side? Well, you can communicate with them. And now I'm not telling you to go out and violate all kinds of ethics rules by calling up a represented party and talking to them, but there are ways that you can communicate with that individual within the ethics rules. You can send a policy limit demand letter. You can send a demand letter. Invite the adjuster or the attorney to share that with their client. You can include all kinds of scary language in the demand letter about exposing that individual to an excess of judgment, exposing their assets to an excess judgment, risking their house. You can point out in the demand letter that insured, the insurance company or the attorney is risking their insured hiring personal counsel or being forced to have to pay for personal counsel to advise them on this kind of a situation. We had exactly this result in an Illinois case fairly recently. We had a $100,000 policy. We had a client with severe injuries. His medical bills were over $200,000. Like Genevieve's case, we had photos that were not favorable as far as damage to the vehicle goes, and we had somewhat questionable liability. But we sent demand letter after demand letter, repeatedly pointing out the jurisdiction that we were in, repeatedly pointing out the risk to that individual of an excess judgment. He hired an attorney, and his attorney sent a letter to the insurance company demanding that they settle for the $100,000, and that's what got the settlement done for us. As soon as they received that letter, they offered the $100,000, and we were able to get the case settled. You can also have the opportunity to do this at deposition. You can ask them, do you know why you're here for your deposition? Are you aware of the damages in this case? Are you aware that we have been making demands to the insurance company to settle this case? You can lay out the risks to them of going to trial, and they will put out they will talk to their attorney about them, and they will put pressure on that attorney or that adjuster to settle the case. And the last thing an insurance company wants to deal with is angry insureds calling them about why they're not settling their case, or making a bunch of noise, or making a bunch of complaints, or filing complaints with the Better Business Bureau, or talking to the media about how their company is not helping them out and is not protecting them despite having paid their premiums. It's the last thing they want to deal with. And so that's something you can use to get a better compensation for your client. You also have the opportunity to use certain things to increase your leverage in cases directly against insurance company or first-party cases where the insurance company is the named defendant, so-and-so versus State Farm, so-and-so versus Allstate or AAA or whoever it may be. That case is really worth more essentially just because the defendant's name on the lawsuit is an insurance company, not an individual defendant. And you don't have to dodge around the issue of the jury not understanding whether or not there's an insurance policy at issue. The insurance company is named. They're aware that there's an insurance issue. And most of them, if they haven't had a bad experience with an insurance company, they will know somebody who's had a bad experience with an insurance company. I would recommend as well always asserting vexatious refusal. My argument about this would be, Your Honor, my client's been paying premiums, they've made a claim, they've refused to pay the claim, or they've refused to offer a satisfactory amount. There's no justification for doing so. I'm entitled to assert vexatious refusal. And you want to let the adjuster know that you plan on asserting vexatious refusal. Why? There's the obvious reason of penalties. There are statutory provisions for extra contractual damages over and above the policy limit. Again, that's something insurance companies are very wary of having to pay, anything over and above the policy limit, but this also vastly broadens the discovery available to you in the case. It not only makes the accident at issue under these cases, it makes the handling of the claim at issue. Therefore, you can get all kinds of discovery, or you have to argue for all kinds of discovery related to that adjuster's handling of that claim. This quickly makes litigation expensive for insurance companies. Now, this next slide I took off the internet, and so you know for a fact that this is absolutely true. Says on here it costs $18,000 to review 1 gigabyte of data. Now, whether or not that specific number is true, I can tell you it's expensive to review a gigabyte of data. I looked, and my email from work over the past year is 10 gigabytes of data. So if you're looking at a $100,000 policy, say it's $10,000 per gigabyte, my email over the past year as an individual would match the amount of the policy limit. You can very quickly make it more trouble than it's worth for the insurance company to continue to fight this, and they'll increase a settlement offer to you in order to avoid having that fight. You want to use it essentially as a weapon in first-party cases. You want to ask for everything you can think of: training, education, software, guidelines, manuals, literature, anything you can think of related to how your claim was handled by the adjuster, anything you can think of related to how the adjuster was trained to handle the types of claims that you are dealing with. This generates a huge amount of documentation. And a large part of the reason why is because the structure of how these companies are organized. If you think about it, you've got the CEO of the company. You have the head of the legal department or claims department that usually reports to the CEO. And below them, you have regional managers. Below them, you have team or office managers. Below them, you have team managers. And then at the bottom, you have an individual. Now, to be somewhat facetious about this issue is we've got to protect our phony baloney jobs, which is a very joking way to put it. But this whole sequence and the people that we deal with for insurance companies are really not the profit-generating wing of the insurance company. That's the investment arm. And so these people that we're talking to, they can't point to their great investment numbers over the past year. They can't point to their great sales numbers over the past year. So at some point, these individuals have to justify what they're doing. And a lot of times what they generate in order to do that is training documentation, documentation on how to handle claims for their adjusters. And they'll do this at every level. They'll do this across the company. And if they're not disciplined about it because of the volume of documentation that's being generated, they're going to have all kinds of inconsistencies related to the document they're producing. Now, the legal department resources are not unlimited. They'll have a team of attorneys, but you want to do everything you can to make it worth their while to pay you, say, an extra $25,000 on your case rather than $30,000 to deal with your discovery requests. And like I said at the start of the presentation, be nice until it's time to not be nice. Well, this is when it's time to not be nice. You want to depose those adjusters. You want to depose those managers. You want to review those documents. And you want to point out your ability to do so at the negotiation stage if you feel that they are vexatiously refusing to pay. And that will allow you to use those inconsistencies at deposition to increase the recovery for your client. You might have to go all the way through and depose an adjuster, but you might be able to get it settled after the deposition if it doesn't go well. And if you're able to repeatedly point out either that they were provided with inconsistent information in order to adjust the claim, or if they were provided with some information but not all the information that the organization used to educate their adjusters, the more you can do to point out that your client's claim was arbitrarily handled in a fashion that wasn't the way that other claims would have been handled, the better off you are. And then again, here's a picture of Patrick Swayze from Roadhouse when he decides not to be nice. And then finally, you can use your liens. And this meme, I actually couldn't find anything on the internet, so I had to make that one up. So if you want to use that, you can pay me $0.25. But you know, Missouri has a favorable lien statute for plaintiffs, limits to half of net proceeds after attorneys' fees and expenses. You can use the liens to negotiate. You can use a low offer at the start to push liens down. If you get a bad first offer, send it to the lien holders. Point out to them that you are getting bad offers and they need to work with you on the liens. You can also use high liens to push the offer up. You can leverage those high liens against an adjuster to point out that the difficulty in resolving the case because of the high liens. Or if it's a reasonable amount, say that your client goes to a physical therapist or a chiropractor who bills very, very reasonably, you can tell the adjuster, we're simply not going to be able to get an adjustment on this because the number is already so low. So you need to pay us the full amount of this. It's already been discounted for you. Illinois has a less favorable lien statute. That's more complicated than Missouri's, as is usually the case in Illinois. Total liens cannot be more than 40%. It potentially leaves the plaintiff on the hook for medical bills. You can still negotiate with the same strategies before. We've had very good luck with this. We've had two cases recently, one that I already pointed out in Illinois with a client with bills of over $200,000, $100,000 policy. We were actually able to negotiate the liens down so low that we were able to satisfy all of his medical bills and put some money in his pocket. And we had another case with a similar result. And in Illinois, because of the risk to your client, it's even more important to get ahead of the game. And finally, don't overpromise and underperform with liens. You want your client pleasantly surprised when they find out how much money they're going to get, not unpleasantly surprised. And then also some just lien reduction arguments you can use.
Can I jump in?
Absolutely, Gary.
I didn't mean that. So we're right at the end of the time. Do you want to close it out? Do you want to take another minute, close it out, or do you mind? Thank you.
Sure. Yeah. I apologies to everybody for running out of time. Gary, believe it or not, Gary Genevieve. Yeah, Gary, Genevieve, and I all like to talk. But my final recommendation, I guess, would be to, if you don't like your adjuster, the recommendation Genevieve made and the example she made was a good one. If you make a high enough demand, you can get a new adjuster. If you file suit, you can often get a new adjuster because it it gets assigned to an attorney, and you'll get a more experienced adjuster on the case, and you often do better. You get an attorney's eyes on it in those circumstances. And sometimes there will be an immediate retainer that goes out the door to outside counsel under certain circumstances, and they'd rather maybe pay you a portion of that than risk having to pay outside counsel a large amount of money up front to take the case over. We had a case where we'd used exactly this. We had a $1,000 offer. We filed suit. It took us about an hour to put the petition together, and the offer went up on a $50,000 policy to $43,000. And so sometimes you can do significantly better either filing suit or threatening to file suit. And that would sum it up for me. Thank you.
Thanks, Tyler. What a great job, Tyler. Thank you so much for the great job you did. Genevieve, thank you very much for the great job you did. I did a terrible job introducing Genevieve Fikes and Tyler Thompson at the beginning, but I put in the chat the link to their bios. So great job. Thank you very much. Remember that we have resources at our firm if anybody needs them. And then one last question. Steve Bernstein poses a great question. Illinois, remember in Illinois, even if you reduce liens in the statute, the client ends up being responsible for them. But what I would do, so Steve asked, what about if it's Missouri people and they get injured in Illinois, what do you do? And so what I would do is if they get their treatment in Missouri, pretend they have a Missouri lien, try to reduce it on that. But in Illinois, we don't use the lien reduction statute as much because we know our clients are ultimately on the hook because there's not that exclusive remedy provision like you have in Missouri. So, when we reduce these Illinois cases, we get them to agree. Say, hey, we show them the statute, blah, blah, blah. We get the best deals we can, and then we confirm it in writing with them so that we have these agreements on the liens. Now, I've never had anybody go back and sue an Illinois client for that, but that leaves them open. And I think you got to tell the client that because you don't want a phone call 6 months later saying, hey, I'm getting sued for this bill, and you left them hanging. So you want to, so we're especially careful in Illinois to make sure we have deals on all the liens. We do that in any case anyway. So there you go. But remember though, in Illinois, you'd rather file suit in Illinois if you can, because if it's an Illinois resident in Steve's hypothetical in the chat, they can't remove it. Number one. Number two is you get the full value of the medical bills, not the reduced amount like you do in Missouri, which is a great advantage. So you if you're going to take the good of Illinois with their full value medical bills, you kind of got to take the corollary of the not quite as strong lien reduction statute. You just deal with it. If anybody has, thanks for everybody for attending. We really appreciate it. If anybody has any other questions, email me, call me. I have a lot of friends on here. And even if you're not my friend yet, I will be. We'll always answer questions for free. Thanks, Tyler, again. Thanks, Genevieve. Again, I'm going to end this CLE section. Thanks, everybody. Enjoy your day. It's beautiful out. Bye.